Hello everybody, my name's Nils O'Donoghue. I'm a partner and solicitor here at Chadwick Lawrence, and I work in our regulatory and crime team. Over the last few months and weeks, we've been advising a lot of clients and getting a lot of queries on immigration law matters. As you are no doubt aware, the landscape has changed following the UK's exit from the EU. So what I'm going to be talking about today is what changes have happened, what changes are happening, and in particular focusing on what you as employers need to do in order to make sure that you're not employing someone who is an illegal worker with no rights to work within the UK. The first change I'd just like to make you aware of is that the government confirmed in the last few days that the deadline for applications to the EU settlement scheme will remain at the 30th of June 2021. It's therefore really important, if you meet the criteria and wish to apply for settled status, for example in the UK as an EU citizen, that you do so on or before the 30th of June 2021. The second really important update is we've been getting a lot of queries from employers asking, as a result of the changes that are happening in immigration law that have been caused by Brexit, what right to work checks they should be applying retrospectively. So it may be, for example, that you employ someone who was not born in the UK but came here as an EU citizen, exercising their free right of movement and their right to work in this country as an EU citizen. The government has issued some guidance on this particular point. Hopefully you will have already conducted a right to work check on that particular individual. And I'll just read from the government guidance, which states there is no requirement for a retrospective right to work check to be undertaken on EU citizens who entered into employment on or before the 30th of June 2021. That is good news, in that if you have employed someone who is an EU citizen and you have conducted that right to work check and they were employed on or before the 30th of June 2021, you will have what is known as a statutory excuse should that person turn out to be someone who doesn't have the right to work in the UK. So if that person doesn't have the right to work in the UK and you've taken, for example, their passport, then you would have what's called the statutory excuse against a penalty if that initial check was undertaken in line with the right to work guidance. However, we would recommend that it's good practice that you continue to undertake right to work checks, even on those you employed on or before the 30th of June 2021. There are a couple of ways to do this, and there is also, in the last few days, on the 18th of June in fact, some new guidance that came out regarding right to work checks. What the new guidance states is there has been some changes as to how you are able to check European Economic Area citizens and prove that they have a right to work in the UK. There has been some changes to the acceptable documents that you are allowed to take as proof of right to work in the UK, and also some adjustments to the right to work checking process, which have been caused by COVID-19. So there are two ways to conduct a right to work check. The first is what's called a manual document-based check, and this involves three steps. The first is that you must obtain a document which shows that that individual, that prospective employee or current employee, if you're rechecking, has the right to work in the UK. The guidance is very clear that that must be an original document, such as a passport, for example. You then must check that document, that it is genuine, valid, and it must be checked in front of the prospective worker, although that can be done by video link as a result of COVID-19. You must then retain that document, and it must be clear, a dated copy, which cannot be altered, and you must record who did the check and when, and retain that document for at least 2 years after employment. There is a list in the guidance of acceptable documents that you must check. Those are in what is called List A, which is for those with a permanent right to work in the UK, and List B for those with a temporary right to work in the UK, and that follow-up checks must be required on those with a temporary right to work in the UK. So, for example, documents on both lists would be a passport or a biometric immigration document. We would recommend, however, that you, if you are checking someone's right to work in the UK, conduct what is known as the online right to work check service. That is done through the Government Home Office portal, and it can be used for those on the EU settlement scheme, for example, those with biometric residence permits, those who are here on points-based system visas, and also some of the miscellaneous categories. What will happen is the prospective worker, or indeed worker, must provide what is known a share code with you once they have proven their right to work. You must then check the details of that shared information by viewing that in the presence of the worker and retain a copy of that check for at least 2 years. It is a much more simpler process than the manual document checking process. If you can't conduct either the manual check or use the online service, then you can use the Home Office's employer checking service to get what is known as a positive variation notice. It is important that you check all prospective employees' right to work in the UK and do not single out people on the basis of their nationality. So even though you know or suspect someone was born in the UK and has lived in the UK their entire lives, you should still check their right to work in this country. If you were to get a right to work check wrong or employ someone illegally, then there could be potential consequences. However, it is unlikely, if you have carried out the right to work check diligently, that the statutory excuse will not be available to you. So it is far more likely that these sanctions will be applicable to those who either don't carry out the check or have behaved fraudulently in some other fashion. In terms of sanction, however, you could be fined up to £20,000 per illegal worker that you employed. There is a possible prison sentence of up to 5 years and an unlimited fine. The closure of your business or a compliance order could be ordered. You could be disqualified as a director or not able to sponsor migrants in the future. There is also what is known as a seizure of earnings order that could be made if you have employed an illegal immigrant. I hope this video has been helpful. I appreciate there's a lot of information. The process is much smoother now as to a right to work check, particularly using the online portal, and I hope you find this video useful. If you do have any further questions, please do not hesitate to get in touch.